Well, let's get started for everybody. Welcome to the first of the briefings that we have for this year. So I don't know how many of you on the call have joined us last year for some of these live briefings, but they're must-watch TV. I have to give you that. You know what I mean? We try to have lively discussions on the really hot topics, and we have a good one for you. So obviously, mental health parity, and it's the act that's out there right now for 2023, trying to make sure that we clear any confusion. And then you got the regulators out there. They may come knocking at the doors. We want to make sure that everybody understands what's going on. No panic. We give you the guidance that you need in order to feel good about compliance in your world. So with that, we have our experts. Joining us today, Darcy Heitzman from Heitzman Law. We're really happy to have you with our panel today, Darcy. Darcy brings over 30 years of experience in employment law, and if you saw the bio, she has more acronyms than any of us in our bios, I have to say. So, take a good look at that, but clearly your expertise is valuable for this conference today, for this live briefing. Also, we have Ray Kim has joined us in the past for these live briefings, and Ray gives us the perspective from the client. Ray is our VP of account management and handles a diverse number of our clients at Corporate Synergy. So he gives us that perspective, and looking for that today. And of course, Dan Cooperstein, who is our internal ERISA attorney, head of compliance. Dan, there's never a want for topics to talk about. And here we are today, and we're talking mental health parity. So why don't you go ahead and give us a little bit of the background of what got us to this point, and then we'll open the discussion up for everybody.
Sure, great. And I think one of the things that's happened, right, with the CAA, the Consolidated Appropriations Act of 2021, is that a lot more people are paying attention to mental health parity in recent years than they have in the past. So I thought it would be a good idea to kind of, talk about how we got here, right? How did mental health parity get so big? How did it go from maybe the little m to capital M, or maybe from the little p in MAPIA to the big cheese? But it is definitely a very important law right now. And so let's go back. Let's go all the way back to the dark ages prior to mental health parity, the 1990s, and really kind of look at what was happening, right? So in 1996, the Mental Health Parity Act was enacted. It was in a time when health insurance plans and policies had these very heavy limits on the mental health coverage, both numerical in nature, things like annual and lifetime cost limits, which we can now call the quantitative limits, and also what we now call the non-quantitative limits, which include things like serious pre-authorization requirements, fail first policies, and things like that just made the mental health coverage inaccessible to many health plan participants, even when there was no sort of numerical limits limiting things. So there's a lot of limits on the mental health coverage, but there were still some problems with the Mental Health Parity Act of 1996. It really only tackled those quantitative limits. It didn't address things like substance use disorders, and so it really wasn't until 2008 when the MAPIA, that is the Mental Health Parity and Addiction Equity Act, was signed into law. And later in 2013, when final regulations were issued under the MAPIA, that's when we really started to see things that more like what we look like today. We saw rules aimed at effectively tackling both those quantitative treatment limitations on mental health coverage and the non-quantitative treatment limits, which we call NQTLs, which, those things that they're not so numerical in nature that can limit the mental health coverage. And that's kind of that's kind of like what we're going to be looking at today and focusing in on. But then there were some more recent things that happened. The ACA was a big one. The MAPIA has one more big change kind of before the CAA, and what we're going to be talking about today, in that when the ACA was applied to the MAPIA, it really expanded the reach of it. It applied the MAPIA to issuers, insurance carriers in the individual market, and qualified health plans offered through exchanges. So it really kind of, expanded the requirements there. And the ACA defined coverage of mental health and substance use treatments as one of the 10 essential health benefits So as a result of that, all of the health insurance plans in the individual and small employer market, both inside and outside the exchanges, had to offer mental health benefits as part of the EHBs. So the ACA kind of takes it to the next level. And then finally, there was this law that came out at the end of the Obama administration, the 21st Century Cures Act, which clarified how the MAPIA would apply to eating disorders, and specifically that eating disorders would be considered to be mental health coverage rather than medical coverage under the MAPIA. And that's kind of like the big picture, I think, of how we kind of got to where we are today with the CAA and this most recent large expansion of the law.
So in a nutshell, and by the way, a couple of people, we see Jacob, we're going to get to your question. By all means, you have a chat feature. It's Zoom. I think everybody's familiar with that now. So go ahead and put your questions into the chat. We may get to it right away, or we may, during the conversation, touch upon it a little bit later, but that will help us make sure that we're answering your questions. But so Dan, that was a great historical perspective going all the way back to the dark ages, as you said. But today in 2023, in short order, what are we concerned about today that we're hearing from Darcy about and others?
Yeah, so the big rule here, right? So the big requirement, right, of all of this, I probably should have gone back and explained the general rule of like what is parity, right? What is mental health parity, right? The general idea, right, is that you want, you don't have to offer a health plan with mental health coverage, but if you are going to be offering mental health coverage on your health plan, your group health plan, health plan has to make sure that there's there's parity between, on the one hand, mental health benefits and substance use disorder benefits on the one hand, and then on the other hand, the medical and surgical coverage or treatment benefits on the other hand. So there has to be some parity. There has to be some equality, so to speak, between these two things. And so when I was talking before about limits, right, the quantitative limits and the non-quantitative limits, that is what the regulators are going to be looking at to see if there's some kind of parity between these two things. What kind of limits are you putting on the mental health coverage? Are those the same kinds of limits that you're putting on the medical coverage or the surgical coverage, right? So that's what's going on here. And as part of enforcing the MAPIA, the federal agencies of the DOL, Treasury or IRS, and HHS, Department of Health and Human Services, are the main federal agencies that enforce it. But there's also these state departments of insurance that can also enforce it. So that's kind of the backdrop. And then what happens with the CAA, and I'll let Darcy kind of go into a little more of the detail, but the CAA comes along, the Consolidated Appropriations Act of 2021, which was signed into law at the end of December of 2020, really gives teeth to the MAPIA by adding a requirement that group health plans have to produce a comparative analysis of the NQTLs, the non-quantitative treatment limitations, applicable to both the mental health and substance use disorder coverage on the one hand, as well as to the medical and surgical benefits on the other hand. And so this comparative analysis has to be made available upon request by any of these agencies, any of those federal agencies or state agencies that request it. And this went into effect on February 10th of 2021, very shortly after this law was signed on December 27th of 2020. And all of the group health plans, whether you're fully insured, self-insured, the way the law was written, everybody that had a group health plan and every group health insurance issuer or insurance carrier, we had to make sure that they were ready to provide this NQTL comparative analysis upon request. So that's kind of the big picture, and hope that's more helpful.
And I guess it's part of what Jacob's question is, okay, hey, how do we put together these comparative analysis? So maybe Darcy, your experience with all of this, there's different, sure. There's self-funded, there's fully funded, and you got TPAs. What do we guide our clients with as it relates to what's their responsibility and where maybe others have responsibility on this?
And I think one of the key things here is to create the proper expectations. When we start talking about mental health and parity, this is not new. I mean, as Dan was going through, this is back to the dark ages. And just as it's not new, we can expect that it's going to continue to be honed and refined as we go forward. So when we talk about, how do we put this together today, please keep in mind that this is for today, and that we need to be very aware that this will continue to change as the facts and circumstances that we deal with change. So what do we have now? We have this analysis, this written analysis, and it needs to cover 6 different categories, which is nice that we've got it identified to 6 different categories. Unfortunately, they're not all that helpful. So we have inpatient, out of network, inpatient, in network, out of patient, out of network, out of patient, in network, emergency care, and prescription drugs. And so what we need to do is look at our analysis in those 6 areas. And within each of those pieces, we need to be able to compare what's happening with respect to the treatment of mental health and substance use disorder as compared to the medical surgical. And so when we look inside those 6 boxes, we have to look at, well, what language is used? What kinds of requirements are used? It's not as simple as looking for specific, running a word search for mental health. We're going to be looking for things like prior authorization, medical necessity, concurrent review. Those are things that are going to apply to mental health as well as the medical surgical. That's what we're going to be comparing. And then to break it down even further, it's not just that language, it's what's behind the language. How is that language interpreted and applied to the particular situation? So it becomes very complex very quickly. So we start with an expectation that we are not going after perfection, we're going after excellence. And we start by breaking down and dealing with the pieces that we know, that we're familiar with.
So with that, and there's another question we have from Tahilia, and I think it's appropriate, Ray, the questions that we're going to get in here almost represent, it's the client perspective. For those that are on the call as clients, their questions are what you and your teams out there in the front lines are representing and bringing to compliance experts. So just weighing in on what you're hearing so far and kind of the temperature of the clients as it relates to this stuff. And then we'll get into answering specifically. Okay, we talked about comparative analysis and what are the tools? Where are the tools? What's the responsibilities? And the question about network access and just things of that nature. But I want to hear from you, Ray, a little bit about the temperature on this as you're seeing it out in the market.
Well, thanks, Brian. I think the temperature is just a little bit of confusion, because if you think about this as being one aspect of many pieces of legislation that have come down the pipeline since really COVID, right? It's one of many, many things, and all of it is accumulating to some general confusion across our book of business and our client partners.
And we have the backdrop of things like HIPAA.
Exactly.
That was horrible when it came through.
Right.
And we still have to do that.
And none of this is very digestible. And when we look at, some of the carrier responses to these pieces of legislation, it comes through and it changes multiple times over until there's some sort of settlement as to, the general consensus of carriers and TPAs doing directionally the same things. And then the clarity finally arrives. And of course, over time, just like when COBRA regulation was enacted, people get used to these things. And so I think initially, to answer your question, there's been a lot of confusion, but it's also really helpful for us as consultants and also clients just thinking about it on their own as to the reasons why these things are happening in the first place. And I think if you think about substance abuse and mental health, there's a stigma out there for these conditions. And over time, that stigma is to the betterment of society, has been slightly improved, and hopefully it becomes just normal course of like any other disease or issue that you have from a health perspective. And so the parity is a good thing ultimately, trying to make things equitable within the health plan. But in order to do that, we have to have some guidelines from the government, and we have to administer it, which is the heavy lifting that we all have to do. So that creates some pressure and confusion that we're hearing in the marketplace, Brian.
Well, let's get right to some of the confusion and the requests that are coming in, not that it's confusion, but getting clarity, seeking clarity. So, as you see here, Jacob asking us to prepare a comparative analysis. How can plan sponsors obtain plan-specific data from TPAs prior to an audit? Currently, they're providing a general report.
And I think if you don't ask for anything more specific, that's what you're going to get.
So
But
do
I
you
think-
ask it like that? I need a detailed report. I need the following things.
And again, it comes back to me as a matter of, let's create the expectation. Now we've got the plan that has the responsibility of putting this together with its various professionals that the plan works with to do this. And you look at the map. I call it mapping. And I look at, okay, what's the nature of the plan? Do we have one option? Do we have more than one option? Okay. Are we insured? Are we self-insured? When we're self-insured, who's the ASO or the TPA? Who are the other service providers that provide services to the plan, the PBM? Do we have separate behavioral health management? Do we have a separate organization that does utilization review and other types of risk management? I like to lay them all out and get those mapped out first, because then when I go back and help the original inquiry to those various service providers, we're able to lay out a narrative almost of what we've already done and what we put together, and now what we are coming to them and asking for. I've still, in many cases, gotten just the generic piece of junk, which is not an acceptable response for a comparative analysis. So when I say junk, it's in the true sense that that's not going to help someone put together their comparative analysis, but it's the starting point, and you keep on them, and you make it very clear that these requests are going to become part of the record that you are putting into your development of your comparative analysis, so that there's, again, creating expectations. We know what we need. We're taking our obligation seriously. We in turn expect you to take your obligation seriously.
I think that
And
last
it's gotten
piece.
better. It's gotten
Yeah,
better.
that last piece might help, a little bit of a threat, because it sounds like, Jacob's trying all of that and he's getting the response that, oh, that's great. Yeah, when you have a DOL audit, then we'll respond. And here he's trying to do the right thing and being prepared, being proactive. And, these are some of the challenges, but, again, you have to show, and I think we've said this before in many of the other types of requirements, good faith actions. And maybe you guys can talk a little bit about that, because I think I started to hear a little bit, Ray, you were talking about it. And I know in our pre-calls about this topic, everyone should be trying to do the right thing. It's what is that level of effort that we should all be trying? And then when we hit those roadblocks, some of those suggestions clearly work with your account management team and your compliance resources and what have you. But sounds like there's some things that they could take action on to help get what they need. But anyway.
Yeah, let me jump in first, and then maybe Dan and Darcy can talk about some of the roadblocks from a legal perspective. But our clients, they really are thinking about their business, not necessarily how to, adhere to APIA, right? So, who do you rely on? Well, of course, the consultants like Corporate Synergies, but also the very vehicles in which the plan is being delivered. That is the carrier and the TPA, right? So that should always be a starting point. And if we think about, Dan had expressed, hey, this law came in 2020, but really the activity around it from the marketplace, from the carriers, has been really culminating in fourth quarter of 2022 and today, right? So because it was it was issued so late in the year in 2021, right?
No,
So-
2020. Yeah, it came out at the end of 2020, and then
I apologize. Yes,
February
2020.
of 2021 was when you were supposed to have this done. But at that point, there were hardly any providers of the comparative analysis that were out there, and things have really changed in the last, as you said, really the last like Q4 of 2022 till now. We've seen a big change happening where there's a lot more options.
However, I do want to point out that if you've got a self-insured plan and you've been following the procedures that you are supposed to follow when having an adverse decision or a denial of a benefit, there should be documentation out there regarding the application of the language to a particular set of circumstances involving surgical and involving mental health. So although it might not be sufficient for, well, it won't be sufficient, it won't have everything that's needed to look at, and it won't be covering perhaps all 6 of the categories. To get that good start, to get that good faith start in all of this, there is information there on a self-insured plan. So we're building, we're trying to get more. And when you look at your third-party service providers, one of the other piece on my map is getting all of the service agreements as well. What are they? What did they agree to do for you? What did they specifically say they weren't going to do for you? And what are the limitations of liability? Because although the regulators may come after the plan sponsor as the plan or the plan fiduciary with respect to the plan, that plan sponsor has contractual obligations with the service providers. And so there is also some leverage that can be used there. And so you have to map it though, because obviously if we're looking at 2 years ago and you just changed your service provider, your ability to exert any real pressure on them went out the door. But for your current one, you've got it. So it's really a map, and it's all facts and circumstances, which makes a template really difficult.
Right.
I don't want to forget Tehilia's question too. So where appropriate, bring up, her question about, talking about parity, talking about quality of care, and her specific question, what responsibility do plans have for ensuring network access for quality providers via single case agreements, et cetera? So where appropriate, maybe speak to that as we go along.
And I'll certainly start it. When you have a self-insured plan, I mean, the putting together of the pieces, are you going to have a network? Are you not? Are you going to have multiple networks? Are there going to be specialty networks or areas of excellence? All of those are design features that then you have to put into kind of motion by getting those contracts. And obviously the typical employer that's sponsoring a plan isn't expected to do that by itself. It then in turn uses professionals to help do that. So I think when we're talking about looking at the program right now, you need, as it exists today, you need to pull on the professionals that helped you put that thing into place, because there is responsibility there as well. And kind of the idea, we're all in this together. So let's figure this out. Let's look at the requirements. What are the requirements for admission into the network? What are the requirements for ongoing participation and review? Are there disparities in the rates? I have a group that is in a rural part of California, and I was basically told, we don't have anybody within 90-minute drive. So what do we do? And so you come across those situations, and that's where we have to, again, the take that I am going forward with is making sure that we document all of those elements as well. So it's not only documenting, is what you're doing good enough, but it's also in some cases explaining why what you're doing isn't good enough, but here are all the things that you put together and tried.
Okay. Do we answer that question? I know it sounds like what's happening out there too is that, as you just said, things are changing for the better, right? As it relates to mental health programs and support for substance abuse and what have you. Sounds like the quality of care, access to care is still somewhat catching up in order for there to be true parity, right? Yeah. So in one case, we're trying to do the right thing, create parity, but yet we're relying a little bit on the quality to be there, to be consistent and on the level of what we have on the medical side and the surgical side and what have you. So
yeah, I want to go back to one thing that Ray said earlier that I think was really really means a lot to this conversation, which is that in probably 99% or more of the cases, the client, the business is focused on their business, right? They don't have, if like they're not going to really know a lot of these things. A lot of this is an actuarial ease or legalese, or it's stuff that most businesses don't really know and can't put together, and they're going to really need to rely on their TPA and their professionals, and their advisors to really kind of help them put this together, because most businesses out there, you can't really go out on your own and do this.
Yeah, the point I was trying to make though is that early on in this response from the carriers, many were saying they would not do the
Right.
comparative
Right.
analysis.
That's what I wanted to talk about that too, right?
And has turned on its head. And now the majority are saying they will, with caveats. And so we have to, as consultants and as clients, read the companion guide that each carrier has, have that on file to show the progression of the change in the response from our carrier and TPA partners. But what we're seeing today as a standard right now is that the carriers and the TPAs are saying they will provide the analysis as a general rule, right? Some are still not, but it's on a standard plan, not necessarily the client's plan. And I have some thoughts about that. I suspect it's because with all the variability of plan designs that each of their clients have, it's really hard to then supply those resources to do the comparative analysis on each individual client nuance differences. And so they say out the gate, we'll go ahead and do it on a standard plan that's similar to yours. And the question will be whether or not that is that best effort that we're looking for, or if it would be, not meeting the requirements of the regulation, right? And so that has a little bit of fuzziness to it that we're going to probably get clarity over time as more clients, particularly larger ones, as Dan intimated earlier in the conversation, start to maybe get some of these demand letters.
Oh, definitely. And I also think that we're seeing more sophistication on the receiving end as well. Instead of me asking the TPA to give me the analysis for this particular plan, I'm saying, TPA, give me the data. We'll run the analysis here. And so, we're getting more sophistication on that end as well.
Right. I think that's a good point. I mean, I think the service providers can do better data analysis even from what the TPAs are sending over. I think that's a really good point. I think one of the things that's really changed too is just that, the carriers, I think I gave an example of this. I know Ray and I were talking about this earlier in an earlier conversation. If you were to talk to a major carrier at the beginning of 2021 about what you're doing for that large self-insured health plan, help get their comparative analysis, they would have just been like, I mean, they hadn't even looked at it yet, right? I mean, no one looked at it, with the exception of maybe one or two very big carriers that had very good legal teams. And I'm not going to name names here, but what I'm trying to say is, it's like, very few of the carriers were really prepared in 2021. And it really wasn't until probably like the end of 2022 that we just saw a major step up of carriers, TPAs, really kind of understanding and appreciating this. Part of that was probably because of a very large settlement against United Healthcare for $15.6 million in late 2021. They kind of woke people up to the fact that the agencies are out there and they're enforcing this. They're doing audits. Also, the DOL EBSA enforcement manual came out saying that this was an enforcement priority, and they were issuing reports to Congress about their findings. So there was more and more things coming out. But like we're talking about, it hasn't been until relatively recently that we're seeing a lot of the carriers and TPAs kind of waking up to what they need to do.
It's interesting. One of the most recent Department of Labor regular audit, I mean, to the extent there's a regular audit coming from them, but not specific to MAPIA at all, just regular audit, had a very high number of requests for different types of data. They're going after data, and did list out, for purposes of documentation that they requested, the MAPIA comparative analysis. Now, it's like everything else. They give you 10 days to do it. And of course, you can't do it in 10 days. But in this case, the MAPIA analysis had not been done. And you can try and get an extension, but you're not going to get an extension long enough to put together a decent comparative analysis for this larger plan. So I think that they're taking a multi-factor approach to it. It's not just the MAPIA focused Department of Labor, for example, audits that you need to be concerned about. You also need to be concerned about agency audits that are not targeted on MAPIA, but will just by nature have MAPIA related questions in them.
That's right. And there's also growing litigation. I think it's important that we not forget
Okay.
that not only has there been this big enforcement increase that we've seen in recent years, but there's actually been a lot more private, plan participants filing lawsuits, even though there's no right of action. There's no private right of action under MAPIA, so there's no ability, so to speak, for an individual to file a complaint under MAPIA grounds alone. They found ways to bring lawsuits under ERISA using different sections of ERISA, and even to bring in the third-party administrators as defendants in these lawsuits. The Second Circuit even recognized, a case against a TPA, that was not under, obviously it was a MAPIA claim, but it was brought under other things. So I think it's important to understand that this isn't just for that one situation where you might have a government agency knocking at your door, asking for the copy of the comparative analysis, but it could also be coming out of the result of participant litigation, or essentially disgruntled employees, right, who are filing a lawsuit.
And that lawsuit may or may not be, legitimate, in the sense that if it is related to an adverse decision and the claim has substance use or mental health aspects to it, that individual, that participant, is entitled to the comparative analysis. And if you're not going to provide it to that participant as part of a claims adjudication, then you're running the risk that you're going to lose the deferential standard by going through exhaustion of the administrative remedies. The administrative record may not be complete, and that could cause some real concern for all of the parties involved in administering and providing funds for a self-insured medical plan.
So Ray, you're representing the clients. You're listening to everything on this call, and what's your takeaway from a client's perspective? What are some of the things that they have access to that they should be asking or taking away from this briefing?
Well, based on that, I'm hiding under a table right now. Yeah, so I think it's really important to use the operative word that I think Darcy said when she was giving that example of a large employer health plan and defining how visible this might be to our really, high profile clients, where there is some emphasis for the government to make sure that they are doing the right things, right? Whereas we have a really wide varying range of clients. And for the vast majority of the clients that we serve, those who are participating today, in fact, may be much smaller. And the ability to do all of these things to get to compliance may not be, cost effective for them. It may not be, something that they want to do on their free time, Brian. And so, again, I go back to doing some of the basics, which is to engage your account management team and engage your carrier to get the progression of how they are going to handle this. And as I had explained, it is evolving, and at the very least, you have documented the capabilities of the carriers and the TPAs, so that when that door should come, the knock on the door should come, and it may be very rare for our smaller clients. We're talking about anywhere, from 50 to 300 lives, maybe even more than that. At least you have exhibited some effort into compliance, right? So this is a little bit one of those things where we just want to scale it, right size scale it for the vast majority of clients who are, very diverse and of different sizes.
And it sounds like that would help to solve a little bit of what Jacob's issue is, and that is he's not getting the more detailed information. He's getting the junk report, as Darcy had said, but it's documented. And they know that it's being documented. And I think that those good faith efforts on the part of everything that we usually talk about, whether it's this compliance with mental health parity or others, when we were talking about the ACA and there's confusion, and my goodness, show good faith effort, show that you're taking it seriously, do the
document everything.
Document it and do the things that are necessary to, CYA, but you're doing it also, and Ray, you said this in the beginning, these are things that you're doing for the right reasons. These are programs and plans, and they're there for a very good reason. Mental health, substance abuse and what have you. The regulations that are coming as a result of all this is because they want this to be something that people have great access to Tehilia's question, not only access to, but access to quality care. And it sounds like from what I'm hearing that all of the pressure that may be coming down from the government and perhaps on the carriers, the TPAs and what have you, will help to maybe bring parity up as it relates to the quality and access and all of those great things. But as it relates to our plan sponsors, administrators, the clients on the call who are trying to do the right things, good faith effort is what we're hearing, and making sure perhaps that they have access to the simplified guidelines for, okay, what are the actions I need to take so that, I don't have to think it up or continually follow up on all of this. I know what my actions should be. So maybe we kind of wrap things up with that in mind so that our clients and those on the call can walk away and say, okay, I have my marching orders, or I just kind of verified, or they verified for me what I was thinking. If we could just close with some of those thoughts.
And I think really, and not to, well, maybe say it again, because I think it's my third time and third time's the charm. I mean, I go back and I map it. I mean, that is, good faith is not going to be having done nothing. So if you've taken, if you've got the map of your plan with your providers, you've got your service contracts, you've identified issues, you've got your stop loss policy, and you can kind of bring that into your risk assessment. If a problem occurs and it's several years down the road and now it's a claim that has to be paid because under the plan we had a mental health parity issue, that's going to relate back today. Your stop loss coverage isn't going to cover it. You need to be taking that into account when you do your risk analysis. What do your different kinds of fiduciary liability coverage say? Your E&O as an employer or a company. I mean, get all of these pieces all together, and you're going to have empty parts where you've made the request for information or data and you haven't received it, but you've got it documented. If you were to be audited, that is a far better place to be in than having done nothing. And if then you end up getting an insufficiency notice from the Department of Labor because some particular aspect of a mental health parity comparison was not done thoroughly enough or properly enough, well, then you got the DOL in there. And we do have that additional pressure to get that information from whoever didn't provide it.
And just a quick reminder for those of you who may have missed it, we have a chat. There's a chat bot at the bottom, or a chat icon, I should say. Click on that if you have questions. I want to make sure that we have some time left here that we do answer the questions. So for instance, what do self-funded clients have to do in order to comply? What do fully insured clients have to do in order to comply? So I think we talked a little bit about that. Let's be very specific where the onus, the responsibility is on those two things, and we'll go from there.
Yeah, I'm sorry. I think I went over that too quickly in the beginning, so I apologize.
All right.
But the way that the MAPIA is worded is that it does apply to all group health plans and insurance issuers, which are carriers, have to comply with this. But as a practical matter, if you are sponsoring if your organization, your client is sponsoring a fully insured plan, the carrier will have already created a comparative analysis for that plan. Now, you still want to make sure that it's right. You want to get a copy of it. You want to request that in writing. Keep those writings where you've requested from your carrier that you've requested a copy of it, and make sure that it looks right and it's consistent with what we've talked about today. So you still need to do those steps if you have a fully insured plan. But if you have a self-insured plan, the liability risk is much greater, because it's really, the onus is really going to be on you, the sponsor of the self-insured plan, as well as the TPAs for that plan, to make sure that this is done right. Now, as a practical reality, this is kind of something we also kind of touched on earlier, right? 99% of companies out there, they're not going to know what these limitations are in the policies and what they mean. And so you're going to really have to work very closely with your TPA, with your carrier partners, your plan service providers, to make sure that you're doing this correctly, because the liability is more, more on your, you have a greater potential for liability if you have a large self-insured plan than if you have a fully insured plan. So that's the short answer. But within that, and so this is something Ray and I have talked about on several occasions, right? There's probably still even a spectrum, right, of
Yes.
where where Ray and I would make the strong recommendation, or just a recommendation that to a client to have a comparative analysis done, in a very comprehensive way. And that is, essentially, if you're a larger self-insured client, if you're more likely to be audited because you're in the public eye, maybe you're a publicly traded company, maybe you're doing things that are in the news, maybe you're going through a lot of M&A events, where these things could come up on due diligence, right? Those types of larger self-insured plan sponsors, those larger self-insured plans and their TPAs, the liability, the risk is much greater for them, because they're more likely to be audited, but also there's more likely to be participant litigation in those cases. And then, of course, if you're getting into that smaller range of like Ray was saying, maybe between 50 and 300 on plan or something like that, even if you are self-insured, you should be doing this as practical reality. It's not as much of it as it's not as much of an immediate thing where you're likely to get audited. You may want to do an assessment first, right? Especially if you haven't made any changes, right? If you haven't done things consciously, so to speak, of changing any kinds of limitations from a numerical or non-quantitative standpoint to the plan, you're probably going to be okay. But we would always, of course, we always recommend that you do the right thing, right? And you do what the law requires and everything else. But your risk is just not going to be as great if you're on the other side of that spectrum. So that's kind of the big picture. Ray, is there anything I missed on that? I know we've had lots of conversations about
No,
this.
I just so glad that you had mentioned it, because I didn't want to minimize what larger clients will have to go through. And I think your advice is really sound one, which is, if you are in that public eye, if you have a lot of propensity to maybe be one of those clients that have an audit bestowed upon them, you definitely want to maybe look to us to line you up with a partner who could do this analysis probably in greater detail than the TPA and the carrier themselves, right?
There's also the issue of who are you using as your third-party administrator? Because as we watch, and as state authorities and federal authorities do come down and issue fines and penalties, remember that those happen because there's a series of events beforehand that went on that were problematic. And so once we get to the point where there's a fine or a penalty, you want to be as a plan sponsor, as the named fiduciary of the plan, I think you want to be aware of who is being looked at closely. In other situations, for example, back when it was HIPAA portability, and it was the non-discrimination factor and actively at work. Here in Minnesota, what happened was the Department of Labor served it on an insurance carrier that also does self-insured administration, asked to see a copy of its plan documents. Once having seen the copy of the plan document and seeing a problem, asked for the list of all the companies that were on that plan document. So you need to be aware of kind of where your service providers are in the mix. And I've even gone to adding a couple of additional questions to RFPs about, are you involved in, have you been involved with, Department of Labor audits, for example, involving MAPIA. Doesn't mean that it's an automatic no, but it's a question that I think now someone who is looking to hire a service provider may want to ask.
Darcy, I'm so glad you said this, because I just want to, sometimes when we're consulting with our clients, at some point we talk about compliance more frequently now than any other time since I've been, in this business, in this industry. There are times where I feel like sometimes we are begging our clients to do a plan document. It really feels like that sometimes is a hurdle. And I talking about things that, it may not be in an audit relative to MAPIA. It could be from something else. So what I would say to our client partners is, let's get a plan document in place, right? And make sure the basics are being done, because it can be as simple as that. and then it's an entree into other things like MAPIA. So get your plan documents done, please.
That's a great point. I think
It
because
is.
yeah, because what can happen, regardless of whether you have a small fully insured plan or a very large self-insured plan, and we saw this in New York with several of our smaller fully insured clients in New York. They were audited as part of that United Healthcare, that big United Healthcare settlement,
Sure.
and they had to share their plan documents. They had to share all of their stuff. It's like they have to open up their books and share everything with the government. So you want to make sure your books look
And
good.
once they're in, they're in.
Exactly, because once they're in, and not just that, they can share information with other agencies, right? They can share information even between state and federal agencies. So you really want to be, this is a really good time to do something like get your plan document done correctly and make sure it's you're in operational compliance, right? That you're doing what you say you're doing. Which is a very basic thing, but it's so important in this era of increased audit activity over MAPIA and other things.
So the sky's not falling. Get your plan docs together. Show good faith effort.
Yep.
Document things. Talk to your account management teams. Talk to your compliance teams. To also make sure that you listen to this one point that Darcy's going to make.
Yes. Okay. Don't just put it on the shelf. Once you've done it, you do need to be kind of like other types of important documentation. I think you need to set it on a schedule that we're going to take a look at this on a regular periodic basis. And when certain things happen, if you change third-party administrators, that's something that even though the language in the plan hasn't changed, how they interpret it, how they administer it may change. Keep that in mind. If you change networks, any of those things that you are going to have to kind of struggle with in a sense right now, the first time you look at things, as you're looking at those things, kind of keep a running checklist of, okay, as we go forward, if some of these things change over time, we need to take a look at whether it impacts this analysis, the MAPIA analysis.
That's a really important point because the law, the CAA, when it amended MAPIA, requires that it be up to date, right? When it's available upon request, it has to be accurate, right? So you don't want to be giving them something that's from 3 years ago, and since then you've changed your network, you have different TPAs, you're in a completely different situation from a Parity standpoint.
Great. Anything else to add from our panels? Anything else to ask out there? I see one more thing. Does a narrow network impact MAPIA?
It could, right?
It could, but I don't think it's necessarily a litmus test.
Right. Exactly. Just because it's narrow doesn't necessarily mean that it's violating the MAPIA, but you want to make sure that if you're, let's say, narrowing the network or you're making changes to the network, that those types of changes are not negatively impacting your analysis, your parity analysis.
And I have been asked about adding specialty networks. If we add, if someone is concerned about the adequacy of their network, or maybe they are just very concerned about this type of issue, you certainly could add a specialty network that would provide additional services with respect to mental health and substance use.
But on the face of it, if it's narrow for mental health, it's also narrow for the surgical benefit, right? So,
well, unless it pertains to specialties. I mean, if it's narrow in the sense that we've got an OBGYN and a podiatrist, but we don't have a mental health, I think we might have an issue.
Right.
Great. Another question. Is there more success using a third party once you are in an audit or using support from your carriers? Teeing that one right up for you, Darcy.
Wow. Well, usually, it's Ray and Dan.
I do have
handling it, and then when something hits the fan.
I do have an opinion on it.
Okay.
Darcy, you're part of an organization who specializes in compliance, and it's all that you do day in and day out. And so when we evaluate,
biased.
Well, I mean, I'm just saying that this is a very niche type of situation where specialization is not a bad thing, right? Especially if again, we're talking about these larger employers. And so carriers are trying to, I'm not trying to disparage carriers. They have a volume that they're dealing with. And so their motivation is to standardize and make it administratively less complicated,
Right.
to not swallow all the resources they have on a particular area of compliance when their main business is to provide healthcare insurance to their constituents. So when we take these types of initiatives to a third party who is specializing in compliance issues, I would venture to guess you're going to have a higher success rate. Yes.
But it's going to involve a cost,
Yes.
and that cost may go kind of with the success rate. But that kind of comes back to where we were talking about earlier, kind of assessing kind of the facts and circumstances of the particular plan. Where does this fall on their scale of risk management? How much are they going to do or be willing to do that perhaps isn't the costly part, but shows a real good degree of good faith efforts? I don't think that, at least I don't expect someone that has, a 5,000 person self-insured plan that operates across the country. I don't think necessarily that the same standard applies in the end of the day to my 150 person, just in Minnesota, just dealing with one service, TPA. I think that it some degree does have that built in, grading schedule. But again, you have to kind of figure out where that fits.
Right. The spectrum that Dan mentioned. Right.
The spectrum.
Yeah.
Yes.
Yeah. And I think certainly if you're on that larger side of the spectrum, I like that Amy is referring to what I've said in past compliance briefings, which is what I call my suspenders approach to staying in compliance. So I think if you're on that larger side of the spectrum, right, where let's say you're a very large organization, you're publicly traded, you have thousands of employees, you're going through substantial M&A activity, you're in the public eye because of a big news event or something, right? Those are the ones where, right, it may be very beneficial to go outside of just working with your carrier and TPA, but it may be worthwhile to go to an actuarial firm or another third-party provider that's going to really specialize in just doing those, doing them really well.
And maybe it's not a complete. They pick out 2 or 3 of the items that have been reported most recently to Congress as being problematic, and they focus on language, and then in terms of operation and application, maybe you're focusing on a few rather than all.
Right. And I think just to answer the rest of Amy's question, I'm sorry, I didn't.
Sorry.
She's asking is the belt and suspenders approach or best practices approach to get the standalone comprehensive comparative analysis done, even if the carrier has sent some of the documentation and say that they'll provide a more full documentation and for an audit if there is an audit, right? But it will not be done unless there's not. This kind of goes back also to the question earlier, right? Where the carriers are going to say, well, we're not going to give you everything unless there's an audit, right? I don't think that, I don't think that just waiting for that stuff in the event of an audit from the carrier is the belt and suspenders approach. The belt and suspenders approach is to have the comprehensive comparative analysis done. That's the right thing. That's like the right thing to do, right? If you're especially if you're on that larger side of the spectrum, and you've got over, let's say, 500 or 1,000 employees on plan, and all those things we talked about before. The belt and suspenders approach to avoiding those fines and regulations really is to get the comprehensive comparative analysis done, and preferably by a firm that can do it the right way. Even if there's a cost to it, and as far as waiting for, getting that information upon, being audited, you may not be able to even get it done. It may not be timely, right? So, right, that's another issue as well. And I know I'm right now, advising our clients as a consultant, and I'm not actually out there in the field. And I know, Darcy, you're actually out there practicing. What have you ever been in a situation like that where, one of your clients is audited, and that was, did the carrier provide more information at that time? And I don't know if you can speak to that, but I just find it to be an unusual thing, that this recent trend that we've seen recently with carriers saying that they'll provide it upon audit.
One of the things that I've done when I get in that position is I ask, we'll take that under consideration, and would you be willing to sign an amendment to the administrative services agreement that if there are damages that result from the delay, that you'll cover 100%, indemnification, hold harmless. Usually we end up with something a little bit faster than prior to, just because we have audit. Maybe it's phased in over a period of time, but I usually get some movement off of that one.
That's good.
I hope Jacob just wrote that one down. I like the way you said that. That's a good,
I was
good
thinking the same
response
thing.
there.
I was thinking the same thing. I was like, write that down, because I wouldn't want to be the client in that situation where I'm the client, right? And I'm getting audited, and now I'm trying to call the carrier. I'm like, where is it? Like, right? I wouldn't want to be the client in that situation. So I think if you're putting yourself in that situation, it's certainly not best practices or belts and suspenders approach.
No.
Well, we can talk compliance all day long, but unfortunately, we only have a few minutes left. And so with that, I want to thank our panelists today, Ray, Dan, and of course, Darcy. Thanks for joining us. I think that was very enlightening. If you didn't get your questions answered, by all means, email us at csg@events@corpsyn.com. Talk to your account management team. We'll make sure we get you the information that you need. And I can't help but feel a little bit superstitious ever since Ray, with my opening of Go Birds, makes me feel all nervous. So I'm going to say Go Chiefs and Go Birds. Hope for a good Super Bowl. Did that solve it, Ray? Am I in the clear now? Did I reverse the mojo? I don't know. I'm just trying to do the right thing here.
I think we need to do a comparative analysis.
Yeah, comparative analysis after the
That's
Super
right.
Bowl. That's what we'll do. Hey guys, thanks so much. Thanks everybody for joining us. So we look forward to our next events. Check out corpsyn.com, go to our events section, and you will see a number of different types of webinars and briefings that we're going to be holding throughout the year. Sign up, make sure you subscribe. You'll be in the know for all of these things that we do. Thanks again. Have a great weekend. Take care.
Thank you.
Great. Thank you.